Welcome. Today's lesson is about the joint venture process. It's the part 2, the agreement. We will talk about financing and the financial policy, setting up facilities and operations, staff recruitment and management, products, marketing, duration and termination of the agreement, and miscellaneous clauses. Financing and financial policy. The joint venture contract should define how the joint venture will be financed. So a financial plan has to be drawn up. Not only a strategic plan and an operational plan to define what the joint venture is expected to do and how it is expected to reach a competitive advantage, but also a financial plan which describes the operative cash flows, so the positive cash flows and the negative cash flows produced by the management of the joint venture. In the financial plan, also we have to describe sources of financing, the costs of financing, so the rate of interest which is paid to the banks and to the other financial institutions, and also general expenses to get the financial resources. And at the end, the financial plan indicates net cash flows produced during different years. Of course, it's not easy to draw a financial plan because it is necessary to foresee the financial results and so financial needs linked to the operative activities of the joint venture. The sources of financing may be shareholders' contributions in equity or also in debt, so shareholders' loans or loans that can be raised in local or foreign currency from local or from foreign banks, and new equity. Another kind of financial source is new debt directly raised by the joint venture, governmental aids, or self-financing. So the joint venture realizes profits and of course use that profit in order to finance new investments or new financial needs. The joint venture agreement usually defines what the financial policy of the joint venture shall be. And it is important that the joint venture agreement, defines the financial policy because first of all, it also defines the commitment of the parties, and also it defines the strength, the financial strength of the joint venture. So it is very important to be very clear about the financial policy, the cash flows, sources of financing, and so on. In the agreement also, it's important to define the policies regarding the distribution of profits or the will of building up financial reserves. Another key point is the debt-to-equity ratio, so the level of indebtedness that on the average is accepted, and of course the appropriate ratio debt to equity depends on the economics of the projects, first of all, depends on the characteristics of the industry, depends on the economic and the financial strengths of the partners, so the availability, the capability of the partners to support, to financially support the joint venture if the joint venture would need new financial resources and the average profitability of the industry. So we don't have a general best debt to equity ratio. The level of debt to equity ratio has to be decided considering different aspects, again, characteristics of the markets, profitability of industry, financial strength of the partners, the economics of the project, of course. The distribution of profits versus building up financial reserves, debt to equity ratio, as we said. For foreign investors, it's very relevant the issue of transfer of wealth created through the joint venture. The wealth created through the joint venture can be in the form of profits, increased value of shares of the joint ventures, or increased value of the invested assets. This issue is also very relevant for the host government, and often it is clearly regulated. It is quite clear that from the point of view of the foreign investors, it is important to be able to transfer the wealth created through the joint venture, maybe to gain, even if quite often the joint venture is developed first for strategic reasons, as we said in other lessons, for example, to establish a good position, a good strategic position in a foreign country. But at the same time, it may be relevant also to gain from the joint venture. From the point of view of the local governments and local stakeholders, it's much better that the wealth created through the joint venture remains in the country, remains invested, it is invested in the country. The attractiveness of a country is determined also by the freedom to remit profits and other entitlements. This is very important. Again, we have to balance the interest of the foreign partners, of the international partners, of the joint ventures, and the interests, the expectations of local governments and local stakeholders. The joint venture contract agrees that the foreign investor will have the right to transfer the counter value of the invested capital, usually. Setting up facilities and operations. First of all, we need the description of facilities, and the parties should agree on the requirements for the joint venture facilities. For example, production capacity of the plant, the required equipment, and all items necessary in operations. The contract might also define the terms and conditions for the construction of plants and state who will be in charge of the construction of plants. So again, it's quite important to define the role of each of the parties, who are the suppliers of the joint venture, who has the responsibility to supply equipment, raw materials, and maybe also construct the plants. Joint ventures accounting and auditing rules have to follow the host country's regulations. And this is quite obvious because, as we said, there is a general conditions in the host country that have to be respected by the joint ventures. Partners can agree on some specific items, for example, about the depreciation rate, even if usually there are accounting rules in different countries, in different regions, which rule the depreciation rate. Anyway, partners can agree on this item. They also can usually agree about the reserve funds, risk funds, for example, social funds, and other rules of auditing, for example, the manner of electing the auditors and their term of office. Staff recruitment and management. The joint venture contract should deal with the relevant aspects of the required staff resources and personnel management. And we have different issues. First of all, qualification. So the definition of job description and requirements for the various posts, various activities in the organization. The executive officers, the key persons, of course. So, and qualification depends on the objectives of the joint venture and the competitive strategy. Recruitment and dismissal, it's another item which is very important. So, different procedures for appropriate selection and grounds for dismissal of staff based on host country's regulations. So it's very important, again, to take in consideration to start, I would say, to start from host countries' laws and regulations, but also it's important that the parties agree about some procedures to select, to train, and maybe to also to dismiss people. Again, appointment of key persons, of key managers, so indications of posts that require particular kind of personnel, for example, expatriates, so people coming from the international partners, and also here some specific procedures. Conditions of employment, so detailed provisions of the specific conditions of employment contract, and training, so policies for training and indication of persons and posts that need special training, special investment in training. Products. It may be useful to specify in the contract that the products to be manufactured by the joint venture. And it's also important to clearly define the concept of product, what we precisely mean by product. So description, technology, and standards. Detailed description of each product that the joint venture has to manufacture during a certain period of time. Indication also whether the products are to be produced by the joint venture on an exclusive or non-exclusive basis. Which technology the joint venture can or has to use in its production, and so if that technology is licensed by one of the partners, and also referring to the national standards and technical norms of the host country, which will have to be observed in the operations about, for example, safety or also environmental effects. Terms and conditions of technology transfer. Technology transfer is a usually very relevant issue in international joint ventures, especially in joint ventures between international company and a company in a developing country. Usually the international company license technology to the joint venture and transfer technological knowledge to the joint venture. And it is very important because this is usually one of the main reasons for the host country's government to support the joint venture itself, and also for the local company to be part of the joint ventures. So it's important to agree terms and conditions of technology transfer. Parties have to explicitly agree on the terms and conditions of the use of the proprietary technology in the joint ventures operations. This agreement about technology transfer can be part of the whole joint venture contract, or sometimes it is in a separate licensing contract that is concluded by the joint venture itself and the licensor. So, terms and conditions of technology transfer. It is very important that the licensing agreement is concluded simultaneously with the joint venture contract. I mean, if the agreement, the licensing agreement, the technology transfer agreement is not part of the joint venture, but it is in a separate licensing contract, it is important that the two contracts are concluded simultaneously. And so usually an unsigned copy of the licensing contract could be appended to the joint venture contract. In the joint venture contract also parties would make reference to the license agreement, and the parties should agree that as soon as the joint venture is incorporated, the license agreement is concluded. So the two contracts, the two kind of agreements are concluded simultaneously. Parties may wish to stipulate in the joint venture contract other subjects relevant to the operations. For example, principles regarding R&D activities. So which R&D activities are fulfilled by the joint ventures, who is in charge to lead research and development activities, and the links between research and development activities fulfilled directly by the joint ventures and similar activities fulfilled by the parties, by the parent companies. Another subject is, for example, principles regarding product quality, composition, specification, durability, performance of the product, which is very important, especially, for example, when the joint venture is a supplier of the parties of, or is a supplier of one of the parties, of one of the parent company. And also in order to respect national laws regarding product quality. Also, remedial procedures in the event that the quality of the product doesn't meet the agreed standard. So, what does it happen if for any reason the product quality doesn't meet the expected standards? How to reach these standards, how to change productions or production conditions, or how to improve procedures in order to meet standards. Product liability insurance is another subject which is usually relevant. Marketing, the joint venture can also have to face marketing issues. Parties have to agree on the basic principles which will be applied in the marketing strategy of the joint venture's product. And this both domestically, and abroad, so both the marketing strategies for the domestic markets and eventually also for the foreign markets where the joint venture is expected to export the products. It's important to remind that not all the joint ventures have marketing problems, because we have joint ventures that are focused, for example, on research, on developing new technological knowledge, or that are focused on increasing the production capacity of the parties. On the other side, many joint ventures have to compete in the final market, so have to manage marketing problems. And of course, so in this case, parties have to agree on some basic marketing principles. I mean, the principles that guide the marketing strategy. Again, we have to balance the need that the joint venture is autonomous and can develop its own marketing strategy autonomously, and the will that the parties have to maintain a certain degree of control of the joint venture activities, and the need to assure the joint venture as a coherent behavior which is coherent with the parties' strategies. Basic marketing principles regard, first of all, the positioning of the product in the market, trademarks and trade names, and communication policies. We also have to remind that sometimes one of the parties can supply the joint venture with the brands, with its own brands, or can license brand to the joint venture. Duration and termination. The duration of a joint venture is a matter that must be stipulated in the joint venture contract and in the articles of association. Also, we have to consider that host country laws may prescribe a minimum and or a maximum duration. Of course, the duration of a joint venture may differ depending also the industry and the project itself. So the duration is a matter that is constrained by local laws, national laws, maybe, or also the intrinsic characteristics of the project or of the industry. Joint ventures are usually established to have a long-term time horizon. It's very important. Joint ventures are a long-term kind of alliance. It's quite obvious, I would say, because it takes we understand it takes a lot of time to understand if a joint venture can be a proper solution to a certain strategy. It takes a long time to prepare the agreement, to reach the agreement, and usually it takes a lot of time to reach good results, to reach positive results from the joint venture. So usually when some companies decide to go for a joint venture, to establish a joint venture, they should have a long-term attitude, a long-term commitment. And a typical joint venture's duration is between 10 and 25 years. Sometimes the party don't even provide a time limit for the duration or agree on the possibility to renew the agreement. Of course, the longer the duration, the lower is the investment to start the joint venture. On the other side, the longer the duration, the more difficult it is to understand and to understand the condition to maintain the proper balancing of costs and revenue and profits from the joint venture for each party. So, of course, when the duration when we have a long-term time horizon, parties have to be ready to accept changing in the characteristics, maybe also in the objective of the joint ventures. The commencement date. The agreement has to take in consideration also the commencement date. It must be distinguished from the effective date of the joint venture contract. The commencement date is the date on which the company comes into existence as a corporate entity in conformity with local laws. So it is the date when the joint venture as an autonomous and legal entity starts living, we could say. It is registered in the company register. The commencement date, of course, is relevant for the provision relating the duration and termination of the joint venture. Termination, if the joint venture has a fixed term duration, its expiration is automatic as established in the joint venture agreement. So it's quite automatic. If the joint venture has indefinite duration, the parties have to agree on the possibility to terminate the joint venture in appropriate termination provisions. So it is important that parties agree the condition, the situation in which the joint venture is terminated. There are 6 main events that make further collaboration undesirable and inconvenient, and so that make the termination convenient for the parties. Well, so first of all, the failure to fulfill the joint venture contract by one or more of the parties. So the parties are, or better, become unable to fulfill the joint venture contract, to respect the commitments, and so it's, of course, the collaboration becomes inconvenient. Second, when there are serious breach of the joint venture contract by one or more of the parties, which is something could be a consequence of the previous event. Third, inability to continue operations due to joint ventures' heavy losses over a specified number of years. And this issue has to be taken in consideration also in connection with the financial condition of the joint venture and the financial strength of the joint venture. So its capability to keep on operating, keep on producing, even if the joint venture at the end of the year has losses. And also the will the parties have to finance again the joint ventures. The joint venture. Okay. Fourth situation is the inability to achieve the established objectives and no reasonable perspective of doing so. So, of course, the joint venture is terminated when, for any reason, it's pretty clear that the joint venture will not manage to reach its strategic objectives. Fifth situation, events of force majeure, which really significantly impair the joint venture's operations. And last, insolvency of one or more of the parties. So termination may also happen because one or more of the parties are simply not any longer interested in the alliance. It is convenient that the agreement indicate the grounds for termination and the conditions under which such grounds can be invoked, like insolvency, breach of the contract, force majeure, and all the different situations we described before. Because of the relevant investment required to establish the joint venture, the parties may wish to restrict the right to terminate at will, at least in the earlier years of the joint venture's life cycle. So it is also important to say that for the parties it's very relevant to recover the investments done to start the joint ventures. So it's very important during the first years of the joint venture's life cycle to maintain the joint venture and to help the joint venture to reach its strategic but also economic objectives. In the medium-long term, it is easier to accept the termination because in most cases the investments done at the beginning have been recovered by the parties, and so the parties are more able to accept a relevant changing in the joint venture's life like termination. Of course, if some external constraints compels the parties to terminate the joint venture, there are no choices. But in the agreement, usually parties accept to restrict the right to terminate at will simply because they stop being interested in the joint venture. The parties also need to agree on their interests and rights and procedures for transferring such interests and rights in the event that one party wants or has to withdraw from the joint venture. Consequences of termination. We have two legal aspects related to the joint venture termination. First of all, the termination of the joint venture agreement itself according to its own provisions, and second, the termination of the partners' legal relationships in the joint venture enterprise. And so both legal aspects have to be considered and managed. In the event of termination, the parties can decide to cease joint venture's operations and liquidate the joint venture enterprise, so to stop all the activities and liquidate the firm, the joint venture enterprise. Or decide that one party will take over the joint venture enterprise and continue operations. We don't have a general rule or general considerations to say which of these two options is better, of course, but in both cases key issues are, first of all, the valuation of the assets and the parties' interests, and second of all, the criteria to return assets and resources to the parties. And usually these issues have to be agreed on in the original contract, in the original agreement. Last point, we have some miscellaneous clauses. Clauses addressing standard problems. So these clauses are found in most agreements, and in the American legal jargon they are referred as boilerplate. Some of these clauses may be relevant in a joint venture agreement, like force majeure, so how to face problems caused by crisis or big negative events called force majeure or acts of God. First of all, a general definition of force majeure events or a specific list of negative events that are considered as that are grouped in this idea, in this set of force majeure, and also describe consequences or expectations admitted in the case of force majeure. Language might seem very simple, but it's very important to have agreements about language, particularly the version that shall be authentic and prevail for the purpose of interpretation. Of course, this is a relevant problem in international joint ventures, and especially between companies that operate in countries that are not used to use English as a general recognized language. The prescription of the language for communications between the partners and the joint ventures, as well as the language for board meetings and the minutes of such meetings. Change of conditions. Clauses that anticipate possible future problems and agree on remedies in the case that such problems occur. So how to face some possible future problems. So agree on basically on the methodology to face possible future problems. So possible change of original conditions. Again, renegotiation clauses. Periodic review of the contract, applicable law, dispute resolution. So miscellaneous clauses can be quite numerous, and they face typical, I mean, they address standard problems that usually parties have to face in a joint venture, also to, as we said, anticipate possible future problems. Thank you.